Dictation will start within 5 seconds. Start. The injunction application was contested by the defendant-appellant by filing written statement pleading therein that he is owner and in possession over the suit property and the same was bequeathed in his favour by his maternal grandfather late Surya Prasad, and the alleged will in favour of Shrimati Kanti is forged and fictitious document. Stop. The defendant-appellant set up an unregistered will dated 28/6/1997 executed by late Surya Prasad in his favour. Stop. It was also alleged that Shrimati Kanti had no right to get freehold deed executed in her favour, and the sale deed, if any, has been executed in favour of the plaintiff-respondent number 1. The same is illegal and ineffective. Stop. Paragraph change. The trial court found that three ingredients for grant of temporary injunction, namely prima-facie case, balance of convenience, and irreparable loss, were in favour of the plaintiff-respondent number 1 and accordingly granted temporary injunction. Stop. The court below further held that plaintiff has a registered sale deed of the suit property in his favour and he has been able to trace the title of his vendor on the basis of a registered will deed and freehold deed, and thus the prima facie case was in his favour. Stop. In respect of evidence adduced by the defendant-appellant in the form of various receipts issued to establish that he was running a marriage hall over the suit property, it was disbelieved by the trial court on the finding that the same appears to have been prepared on one day in the same ink and handwriting. Stop. The claim of the defendant-appellant was based on the basis of an unregistered will. Stop. Whereas the plaintiff-respondent number 1 has set up the case on the basis of a registered will in favour of his vendor, who happened to be the daughter of late Surya Prasad. Stop. Further, there was a registered freehold deed executed in favour of the vendor of the plaintiff-respondent number 1, and the plaintiff was claiming rights on the basis of a registered sale deed in his favour executed by a person who had a registered freehold deed in her favour. Stop. Thus, there was a serious issue required to be tried, and there was a prima facie case in favour of the plaintiff-respondent. Stop. Paragraph change. Insofar as the defense in the form of receipts filed by the defendant-appellant are concerned, the trial court found that there were prepared in the same ink and handwriting, hence disbelieved the same. Stop. We do not find any illegality in the said finding. Stop. Learned counsel for the appellant has placed special emphasis on his argument that the court below has failed to record the fact that possession of the respondent number 1 plaintiff on the suit property has been prima facie established. He submits further that a person who is not in possession cannot seek relief of injunction. Even then, the court below has granted temporary injunction in favor of the respondent number 1 dash plaintiff. Stop.